A veto, Latin for "I forbid," is the power to unilaterally stop an official action, especially the enactment of legislation. A veto can be absolute, as for instance in the United Nations Security Council, whose permanent members can block any resolution, or it can be limited, as in the legislative process of the United States, where a two-thirds vote in both the House and Senate may override a presidential veto of legislation. A veto gives power only to stop changes, not to adopt them. Thus a veto allows its holder to protect the status quo. The concept of a veto body originated with the Roman consuls and tribunes. Either of the two consuls holding office in a given year could block a military or civil decision by the other. Any tribune had the power to unilaterally block legislation passed by the Roman Senate. Roman veto. The institution of the veto, known to the Romans as the intercessio, was adopted by the Roman Republic in the 6th century BC to enable the tribunes to protect the interests of the plebs from the encroachments of the patricians, who dominated the Senate. A tribune's veto did not prevent the Senate from passing a bill, but meant that it was denied the force of law. The tribunes could also use the veto to prevent a bill from being brought before the plebeian assembly. The consuls also had the power of veto, as decision-making generally required the assent of both consuls. If one disagreed, either could invoke the intercessio to block the action of the other. The veto was an essential component of the Roman conception of power being wielded not only to manage state affairs but to moderate and restrict the power of the state's high officials and institutions. Westminster Systems. In Westminster Systems and most constitutional monarchies, the power to veto legislation by withholding the royal assent is a rarely used reserve power of the monarch. In practice, the Crown follows the convention of exercising its prerogative on the advice of its chief advisor, the Prime Minister. Australia. Since the Statute of Westminster, the United Kingdom Parliament may not repeal any act of the Parliament of the Commonwealth of Australia on the grounds that is repugnant to the laws and interests of the United Kingdom. Other countries in the Commonwealth of Nations, such as Canada and New Zealand, are likewise affected. However, according to the Australian Constitution, the Queen may veto a bill that has been given royal assent by the Governor-General within 1 year of their legislation being assented to. This power has never been used. The Australian Governor-General himself or herself has, in theory, power to veto, or more technically, withhold assent to, a bill passed by both houses of the Australian Parliament, and contrary to the advice of the Prime Minister. This may be done without consulting the sovereign as per Section 58 of the Constitution. When a proposed law passed by both houses of the Parliament is presented to the Governor-General for the Queen's assent, he shall declare, according to his discretion, but subject to this Constitution, that he assents in the Queen's name, or that he withholds assent, or that he reserves the law for the Queen's pleasure. The Governor-General may return to the House in which it originated any proposed law so presented to him, and may transmit therewith any amendments which he may recommend, and the Houses may deal with the recommendation. This reserve power is, however, constitutionally arguable, and it is difficult to foresee an occasion when such a power would need to be exercised. It is possible that a Governor-General might so act if a bill passed by the Parliament was in violation of the Constitution. One might argue, however, that a government would be hardly likely to present a bill which is so open to rejection. Many of the viceregal reserve powers are untested, because of the brief constitutional history of the Commonwealth of Australia, and the observance of the convention that the head of state acts upon the advice of his or her chief minister. The power may also be used in a situation where the Parliament, usually a hung Parliament, passes a bill without the blessing of the executive. The Governor-General, on the advice of the executive, could withhold consent from the bill, thereby preventing its passage into law. With regard to the 6 governors of the states which are federated under the Australian Commonwealth, a somewhat different situation exists. Until the Australia Act 1986, each state was constitutionally dependent upon the British Crown directly. Since 1986, however, they are fully independent entities, although the Queen still appoints governors on the advice of the state head of government, the Premier. So the Crown may not veto any act of a state governor or state legislature. Paradoxically, the states are more independent of the Crown than the federal government and legislature. State constitutions determine what role a governor plays. In general, the governor exercises the powers the sovereign would have, including the power to withhold the royal assent. Canada. According to the Constitution Act, 1867, the Governor-General of Canada may veto a bill by refusing royal assent. If the Governor-General withholds the Queen's assent, the sovereign may within 2 years disallow the bill, thereby vetoing the law in question. However, this power has never been used. Provincial viceroys, called lieutenant governors, however, are able to reserve royal assent to provincial bills for the Governor-General. This clause was last invoked in 1961 by the Lieutenant Governor of Saskatchewan. India. In India, the President has 3 veto powers, i.e., absolute, suspension and pocket. The President can send the bill back to Parliament for changes, which constitutes a limited veto that can be overridden by a simple majority. But the bill reconsidered by the Parliament becomes a law with or without the assent of President after 14 days. The President can also take no action indefinitely on a bill, sometimes referred to as a pocket veto. The President can refuse to assent, which constitutes an absolute veto. Spain. In Spain, Article 115 of the Constitution provides that the King shall give his assent to laws passed by the General Courts within 15 days after their final passing by them. The absence of the royal assent, although not constitutionally provided, would mean the bill did not become law. United Kingdom. In the United Kingdom, the royal veto was last exercised in 1708 by Queen Anne with the Scottish Militia Bill 1708. The House of Lords used to have an effective power of veto by refusing to concur in bills adopted by the House of Commons. However, reform first by a Liberal government and then by a Labour government has limited its powers. The Parliament Acts of 1911 and 1949 reduced its powers. They can now only amend and delay legislation. They can delay legislation for up to 1 year. Under the 1911 Act, money bills cannot be delayed, and under the Salisbury Convention, the Lords cannot delay any bills set out in the governing party's manifesto. United States. According to the Constitution, all legislation passed by both houses of Congress must be presented to the President. This presentation is in the President's capacity as head of state. If the President approves of the legislation, he or she signs it into law. According to Article 1, Section 7 of the Constitution, when the President chooses, if he or she does not approve, he or she must return the bill, unsigned, within 10 days, excluding Sundays, to the House of the United States Congress in which it originated, while the Congress is in session. The President is constitutionally required to state his or her objections to their legislation in writing, and the Congress is constitutionally required to consider them, and to reconsider the legislation. This action, in effect, is a veto. If the Congress overrides the veto by a 2/3 majority in each house, it becomes law without the President's signature. Otherwise, the bill fails to become law unless it is presented to the President again and he or she chooses to sign it. Historically, the Congress overrides the presidential veto less than 10% of the time. A bill can also become law without the President's signature if, after it is presented to him or her, he or she simply fails to sign it within the 10 days noted. If there are fewer than 10 days left in the session before Congress adjourns, and if Congress does so adjourn before the 10 days have expired in which the President might sign the bill, then the bill fails to become law. This procedure, when used as a formal device, is called a pocket veto. Modifications declared unconstitutional in 1983, the Supreme Court had struck down the one-house legislative veto on separation of powers grounds and on grounds that the action by one house of Congress violated the constitutional requirement of bicameralism. The case was Inns v. Chadha, concerning a foreign exchange student in Ohio who had been born in Kenya but whose parents were from India. Because he was not born in India, he was not an Indian citizen. Because his parents were not Kenyan citizens, he was not Kenyan. Thus, he had nowhere to go when his student visa expired because neither country would take him. So he overstayed his visa and was ordered to show cause why he should not be deported from the United States. The Immigration and Nationality Act was one of many acts of Congress passed since the 1930s, which contained a provision allowing either house of that legislature to nullify decisions of agencies in the executive branch simply by passing the resolution. In this case, Chadha's deportation was suspended and the House of Representatives passed a resolution overturning the suspension, so that the deportation proceedings would continue. This, the court held, amounted to the House of Representatives passing legislation without the concurrence of the Senate, and without presenting their legislation to the President for consideration and approval. Thus, the constitutional principle of bicameralism and the separation of powers doctrine were disregarded in this case, and this legislative veto of executive decisions was struck down. In 1996, the United States Congress passed, and President Bill Clinton signed, the Line Item Veto Act of 1996. This act allowed the president to veto individual items of budgeted expenditures from appropriations bills instead of vetoing the entire bill and sending it back to the Congress. However, this line item veto was immediately challenged by members of Congress who disagreed with it. In 1998, the Supreme Court declared the line item veto unconstitutional. The court found the language of the Constitution required each bill presented to the President to be either approved or rejected as a whole, an action by which the President might pick and choose which parts of the bill to approve or not approve amounted to the President acting as a legislator instead of an executive and head of state, and particularly as a single legislator acting in place of the entire Congress, thereby violating the separation of powers doctrine. In 2006, Senator Bill Frist introduced the Legislative Line Item Veto Act of 2006 in the United States Senate, rather than provide for an actual legislative veto. However, the procedure created by the act provides that if the President should recommend rescission of a budgetary line item from a budget bill he previously signed into law, a power he already possesses, pursuant to U.S. Const. Art. 2, the Congress must vote on his request within 10 days. Because the legislation that is the subject of the President's request was already enacted and signed into law, the vote by the Congress would be ordinary legislative action, not any kind of veto, whether line item, legislative or any other sort. The House passed this measure, but the Senate never considered it, so the bill expired and never became law. Early federal history. Intent of the framers. During the Constitutional Convention, the veto was routinely referred to as a revisionary power. The veto was constructed not as an absolute veto, but rather with limits, such as that Congress can override a veto, and that a president must state their objections in writing. These limits would have been important in the minds of the founders, given that in Britain the monarch retained an absolute veto. Further, as Elbridge Gerry explained in the final days of the convention, the primary object of the revisionary check of the president is not to protect the general interest, but to defend his own department. During the Constitutional Convention, the framers overwhelmingly rejected 3 proposals for an absolute veto. Under the Articles and Constitution, the presidents of the Continental Congress did not have the power of veto. The president could not veto an act of Congress under the Articles of Confederation, but he possessed certain recess and reserve powers that were not necessarily available to the predecessor president of the Continental Congress. It was only with the enactment of the United States Constitution that veto power was conferred upon the person titled President of the United States. The presidential veto power was first exercised on 5 April 1792 when President George Washington vetoed a bill outlining a new apportionment formula, submitted by then-Secretary of State Thomas Jefferson. Apportionment described how Congress divides seats in the House of Representatives among the states based on the U.S. Census figures. President Washington thought the bill gave an unfair advantage to the northern states. The Congress first overrode a presidential veto on 3 March 1845. U.S. states, veto powers, and override authority or U.S. states also have a provision by which legislative decisions can be vetoed by the governor. In addition to the ability to veto an entire bill as a package, many states allow the governor to exercise specialty veto authority to strike or revise portions of a bill without striking the whole bill. A mandatory veto allows a governor to amend bills that have been passed by the legislature. Revisions are subject to confirmation or rejection by the legislature. Line-item veto allows a governor to remove specific sections of a bill that has been passed by the legislature. Deletions can be overridden by the legislature. Pocket veto: any bill presented to a governor after a session has ended must be signed to become law. A governor can refuse to sign such a bill and it will expire. Such vetoes cannot be overridden. Reduction veto allows a governor to reduce the amounts budgeted for spending items. Reductions can be overridden by the legislature. Package veto allows a governor to veto the entire bill. Package vetoes can be overridden by the legislature.